Good morning. Are you Fabian Hall?
Mm.
And Mr. Hall was previously in court, entered a plea of guilty to the third-degree felony offense of injury to a child, elderly or disabled person. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir.
I have to.
Are there any additions or corrections,
No, yeah.
explanations?
Yeah.
The PSI kind of gives me some hesitancy.
It gives me a lot of hesitancy.
His response was when he was given an opportunity seemed to overwhelmingly mitigate and minimize his role in his offense. Obviously, from the perspective as Mr. Riley writes it, that he has no criminal history, doesn't appear to have a substance abuse issue, so to speak, that he would be a candidate for promotion, but based on the totality of everything, and especially Judge, his evaluation of the Balkans, I defer to what I think.
And I would also comment that the PSI itself talks about the fact that there's several factors in the defendant's background circumstances that favor leniency at sentencing.
Well,
And
all of that depends on, he pled guilty to this. And then his version is, I was being a good father that I am. I took the kids to play. We laughed, we ate, we enjoyed. My daughter was feeling bad and I ignored the signs of sickness. She had a lacerated liver. And the allegation is that he kicked her. There's nothing in here. This is a complete denial of.
no, it wasn't meant to. I talked to him extensively about that, Judge. What he tells me, and I have not talked to the probation department who wrote that, is that, and what he would tell you, that he never understood the officer to ask him specifically what is his version.
This is in writing. He wrote this.
And then he wrote this because he explained to you why. Go ahead.
Okay, so he asked me if there was anything else I wanted to say. I'll just let him know that yeah, I'm a good father and I do what I can for my kids. That was all.
But you were not denying the fact that you committed the offense.
So did you or did you not?
Oh yeah, I was that's what I was saying. Yeah, I played guilty to yes.
I know you pled guilty.
Yes.
I was here for that.
Mhm.
Did you do what they charged you with? So what is the status now as far as access to children? It looks like there wasn't cooperation with Child Protective Service, which also gives me some concern. What do you see your children now?
Yeah, I do.
Do you have a court order?
Not the one that I'm not supposed to.
No, I'm talking about a court order from family court or anything that day.
Did you go through family?
Like visitation.
No, I wasn't given it.
Okay.
So you've got 5 children. And this says you live with your girlfriend and 4 of the children. Is that correct?
Yes.
But you did not complete the CPS service plan? CPS got involved, right?
Yes, ma'am.
And from what I'm reading, it looks like there was some resistance to following all of the recommendations and service plan from CPS. So
no resistance. I followed everything they asked me for.
Yeah, that was a surprise to us. Is we had understood that he had done everything they asked him to do under the family plan.
And so does CPS, did they give you permission to be
They told me I would
with your children?
will have to be supervised with it, and I have been getting supervised. They never told me anything out of ordinary.
So you're never at home with these children by themselves?
No. And I'm always at work, so never at home by myself.
Where's the 5th child? There's 5 and you live with 4.
Yes, ma'am.
Which one do you not live with?
No, that's Nakai Fields.
And who does Nakaya live with? Do you see her?
No, ma'am. They wanted me not to.
Right. So that's the victim in this office.
Yes.
So with CPS, what exactly did you do? Did you take a parenting class?
No.
You did not?
No, I really didn't know what I had to do. Nobody told me nothing. That's why I'm kind of confused about it.
Judge, if the court needs more information about that, we very easy for me to obtain if you might give us either a little bit of time this morning. Or
I mean, we have no problem
Yeah,
as a condition of probation. We have no problem as a condition of probation, telling, saying that he must complete the recommendations of the CPS as far as like a family plan and anything.
Well, and I don't know what their recommendations are at this point, and it doesn't necessarily look to me if it's anyway. So here's what I'm going to do. I'm going to find Mr. Hall that you previously entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings and place you on probation for 7 years. You're ordered to pay a $1,500 fine and to follow all of the rules and conditions of probation. That includes entering and successfully completing a parenting course that is approved by probation. So at this point, since I'm not real sure where CPS is on this, I'm going to order myself that you do the parenting class. If CPS is still involved, I'm also going to order that you follow all of their rules and conditions, which does include that you not have contact with Nakia, and that you have no unsupervised contact with any child, including any of your own.
Yes, ma'am.
So if mom has to go out and go to the store, you don't get to stay home with the kids. Do you understand?
Yes, ma'am.
If you do, then it's a violation of this probation. You'll be right back here in court. If I find out about it, you could go to prison for up to 10 years. Do you understand? If you do everything that you're supposed to on this probation and figure out, obviously, better ways to handle the children, then at some point, if you've completed all the classes and done everything that you're supposed to, there's the possibility of some further contact with your children. And this is an opportunity where you don't have this felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have this conviction. The other side of that, though, like I said, is if you violate any condition of probation, you'll be back here in court and you could be facing the 10-year sentence and the conviction. Do you understand?
Yes,
Or up to a 10-year sentence.
Yes, ma'am.
I do want to make sure, it looks like if there is a referral for mental health services, you have to follow through with any of those, whether you feel like you need it or not. If probation has you assessed and they feel like there's some counseling or something that would help you, you will be required to do that. Also, you will be required to have a substance abuse assessment and follow any recommendations of that. So it looks like there has been some marijuana use in the past. And that for some reason is on, when's the last time you used marijuana?
Last year, say December.
So if I test you today, you shouldn't have anything in your system. Have a seat in the jury box. Let's test that before I go any further. Do some drug tests today.
That's what you're on.
Yes.
She got.
Which one? It's yes, loose patrons.
It's on the phone, just need to take them out. We cheer in the afternoon and she was supposed to be until then. She said she'd be on her way. She's looking for work and it'll take her a few hours.
Does she have a misdemeanor pending also?
I'm just gonna say. She should be on the weekend. She thought she had it.
At 2, yeah. For sure, she should be already on her way.
Okay,
So-
when I went to say it to you, I realized how that did not say.
And this has a notation that this is an out-of-town bondsman and you called them specifically, correct?
Yes, ma'am.
All right, I'm not going to do anything about it. That'll stay safe. If she shows up, then today,
Yes, ma'am.
at some point, then I'll reconsider, but she needs to get here today, even if it means reset her case. The Mr. Smith on Cedric Franklin sentencing.
Sir.
Franklin?
All right, Mr. Franklin tested negative, which obviously is good. So at this time, any reason not to go forward with sentencing? All right, then, Mr. Franklin, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do everything that you're supposed to on this probation, this is a great opportunity because you will be able to serve that 10-year sentence while you're out on probation. And if you violate any condition of probation, then you can be brought back into court. You could be your probation revoked, and you can be facing that 10-year sentence that you've agreed to. Do you understand?
Understood.
I'm going to hand you the trial court certification that shows that this was an agreement that I followed. And so you've waived your right to appeal. Do you have a question?
If I complete this successfully, would this go on my record?
Yeah, this is a conviction. It's on your record. And that's based on the criminal history that you already have. You've already had 2 probations that were revoked. So your agreement was for the straight probation. I also handed you an admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Smith. All right. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. This was this. Mr. Kevin Lane on Ahmad LeBlanc. All right, so on Mr. LeBlanc's case, which is 21-36444, we went through the motion already, which is a motion to revoke unadjudicated probation, where Mr. LeBlanc is on probation for the 2nd-degree felony offense of aggravated assault. He pled not true to counts 1, 2, no, pled true to counts 1, 2, and 3. I got a drug test done. Mr. LeBlanc tested positive for THC. And so obviously, when's the last time you smoked marijuana?
The day I had to turn myself in. But the probation.
What made you think that would be a great idea? So he pled true to a possession of a controlled substance, a new offense, tested positive. So at this time, Mr. LeBlanc, you're on probation already. I granted you a bond because of that deferred probation status, but the fact that you're on probation and on bond and testing positive for THC, there's clearly an issue. At this time, I'm going to find that it is in the best interest of you and the community that there is not going to be a bond. I'm going to withdraw your bond at this time and find those violations. And then what I'm going to do is have probation do an updated report. You've pled true that you're obviously there's an issue. There's a new felony offense. And so we'll get an updated report and then we'll see what we're going to do at your probation sentencing. Okay, you can go back with the bailiff. Go on your check after the day. It's been that. Mr. Burbank, you have Kingston Walker.
I do, Judge.
That one goes with this. Good morning, sir. Are you Kingston Walker?
Yes, ma'am.
And Mr. Walker is charged in cause number 25 DCCR 0861 with tampering or fabricating physical evidence, and then 25 DCCR 0862 with possession of a prohibited weapon. Mr. Burbank, what is the announcement?
Asking for one reset, Judge. I just have to finish it up. It should be disposed of.
All right. Any issues, Mr. Smith? All right, we'll just do a normal reset. Mr. Walker, make sure you stay in touch with Mr. Burbank, visit with him before that next court date so that you guys can visit about your case and we'll try to get an announcement at that court date. You're free to go, sir. Thank you.
Excuse me.
Yes, sir. Thank you. And good morning, Mr. Burbank.
Excuse.
You can get one on the end for work. Mr. Galmore,
Yes, sir.
you have Carlos Betancourt.
We have submitted a plea on that one.
I've got it.
Okay.
Good morning, sir. Are you Carlos Mascora Betancourt?
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
You will.
Mr. Betancourt, in cause number 25 DCCR 0798, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 6th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Also, the state would agree if you're eligible and everything else kind of falls into line that they would recommend expunction under Article 55A.101A2. Is that your understanding?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Betancourt's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there. All right?
Yes.
Okay, we'll see you back at sentencing.
Thank you.
And then, Mr. Galmore, you have Christopher Stiles. Did you
Okay,
have
no.
your certification on?
I'll get that.
Did he sign it?
No, he has not, but I'll.
Make sure he does that before y'all leave, please. I read Monday. Well, it's been a full amazing. What it's been.
That's true, it was, huh?
Yeah. Huh? Yeah. The dog, I mean, it's not alarm, it's just normal, but everybody's, yeah, there was a lot. Just good. All right, on Christopher Stiles.
We're gonna sign that one up, Judge.
Okay, I'll hold it. Thank you. Mr. Gertz, you have Shay Morgan. I don't see paperwork or a rejection, and this was the last reset. So do I need to hold it for a few
We've got
minutes?
a deal worked out to exchange restitution for dismissal. We are finalizing, working on getting the funds together.
How long
Sorry,
will that
shoot.
take?
Probably 30 days realistically, but we'll get it to you and then we'll get it to the state and then they would just issue a dismissal.
But this should have been done. I mean, you've been on since last July. And I said this was the last one, and I think probably for that purpose, last month, right?
We're working on
Should not have given him alternative offers to resolve it. Should she not have it up front, or should she be able to come up with half of it up front? But
All right, 2 weeks. Ms. Morgan, you have 2 weeks. If you get the restitution by then, great. If not, then there needs to be something alternative done. There will not be another reset after that one. All right? We'll see you in 2 weeks.
Thank you.
Thank you.
Wait from the outside. Hey, Judge, can I play some?
Okay, we're back on the record. Cause numbers 25 DCCR 0297, 19 33340, and 20 36095. Y'all have an opportunity to kind of go back through the receipts as far as that time frame legally that we can kind of talk about on this case.
We have to, with,
Mr. Coleman came up with a number of $2,407. In speaking with Ms. Leonard, her recollection actually is a little bit more than that. She thinks somewhere between $3,000 and $4,000. We had agreed to, or we had offered $3,500. And I think that Ms. Leonard feels comfortable paying back as far as restitution.
So if she agrees that it's between $3,500 and $4,000,
Between $3,000 and $4,000.
3 and 4, I'm more inclined to go on the higher end of that, just based on the nature of the time frame that we're unable legally to look back on. And so I would be inclined to order the 4,000, Mr. Coleman.
Judge, that makes perfect sense. I've spoken with the complainant who is here today, the district
Yes.
manager for Sutherland's. His position is he'd like to be heard by the court. He was thinking that if the defendant was placed on probation, that they'd be getting a lot more in the way of restitution. I explained to him how we arrived at where we are, but he still wants to address the court and quite possibly ask the court to reconsider. If he's not going to get more than what he's getting in the way of restitution, he would want the court to reconsider some type of form of jail time.
Okay, and sir, you can come on up. Miss Leonard, if you'll just kind of slide around.
Right, for the record, the witness's name is David Powell.
Thank you. Good morning, Mr. Powell. Thank you for being patient with us this morning. It was a big morning here. Mr. Powell, would you please raise your right hand?
Yes.
Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you, sir.
Mhm.
And Mr. Powell, you kind of heard where we are on this legally. I understand there's a significant amount of restitution that you believe could potentially be owed based on some prior dealings that aren't within the time frame that we're talking about. Is that correct?
That's correct.
And I'm going to just, if it's okay with everybody, just let Mr. Powell tell me what he needs to. If there's any questions of him after that, I'll gladly let you guys ask questions. But Mr. Powell, you can go ahead if you would like.
I don't have any questions. Tommy explained to me what the restitution would be. We lost a substantial amount of money.
Sure.
And if that's what we're going to be awarded, I would prefer jail time versus the restitution.
Okay. I understand that completely. Anything else that you'd like to say? Thank you. Go ahead, Mr. Coleman.
Just really briefly, Mr. Powell, was any of these losses covered by insurance?
No.
What, if any, effect did it have on Sutherland and its practices going forward?
Other than the loss of funds, quite a few effects. We had to change the way our IT department had to change the way some of our transactions are rang, and that they can be rang and returned and voided. Myself, I'm a district manager, so I manage several stores. So myself, it added quite a bit to my duties as far as verifying reports, verifying voids, verifying the way transactions are run, and looking at each store transactions daily and talking to the managers to verify why this transaction was running in a certain way and why it was voided. So it adds quite a bit more to my morning. Before I can get started on my store, which is Beaumont, I have to verify the other stores, and I have to go through and do a lot of extra work.
And Mr. Powell, we are cutting this down a lot more than what you and I kind of rehearsed or scripted. Just high level, 30,000 foot level for the judge. We have documents here that will show that this defendant essentially engaged in a scheme of enlisting other people or asking other people, but unbeknownst to them, to void transactions and later on remove money from the register. Am I dumbing it down too much?
No, that's actually correct.
Okay.
That's pretty much how we found it because it was a set pattern. The way the system works is if you void a transaction, the transaction disappears. So if you void a transaction and take the money out, we don't know because the money's gone because the transaction's gone. What was happening was a transaction will be ran, the customer pays cash. I reprint the receipt so I know how much to ask for a void for. They would void the transaction, and now I know how much money to take out of the drawer. So what I get in the morning in the past, on my reports, it just says there was a void on, done this day for this amount of money. It doesn't say why or how much or who. Now, and of course, with me trusting my cashiers and my office crew, we have a void, and it says that the customer paid with a card and not cash. I assume that that's what happened, and I let it go.
We've got 139 pages of documents, and these documents essentially show 68 voided transactions totaling $31,134.86, going back to July of 2022, correct?
Correct.
State offer states too, Judge.
I would object to any portion outside the date range in the indictment, Judge, but other than that, I don't have any objection to it.
I mean, it's been testified to. I don't think I need those as I'm going to take it into consideration to the extent that I think appropriate. Obviously, the amount have limited, but the fact that there was potentially more that for some reason wasn't in that indictment, I will take notice of that.
As the witness, Judge.
Thank you. Any questions?
No questions for Mr. Powell, Judge. I know he's been here at every court date. I want to
Yeah.
first apologize to him for having to come here and thank him for being here as well.
Thank you very much, Mr. Powell. You can have a seat.
A courtroom session unfolds with multiple serious cases, but one stands out: a father charged with injury to a child. Despite pleading guilty, he attempts to present himself as caring, claiming he never meant harm. However, the judge quickly notices contradictions between his statements and the evidence, raising serious concerns about accountability. As questioning continues, more issues surface: failure to follow child protective services, lack of parenting classes, and unclear supervision of his children. The tension builds as the judge weighs not just the crime, but the pattern of behavior behind it. In the end, instead of immediate prison time, the judge gives a strict probation sentence with heavy conditions, making it clear this is a final chance. Any mistake could lead to years behind bars. This moment highlights a powerful truth. In court, it's not just about what you say, it's about what your actions prove. And sometimes, one decision determines everything.